Hi everyone, I am Rinal Satish. I am an Associate Professor of Law at the National Law University, Delhi. Today we will be discussing the module on Protection of Children from Sexual Offences Act 2012, that is the POCSO Act. The Protection of Children from Sexual Offences Act, hereinafter which I will be referring to as POCSO, was enacted by Parliament in 2012 and came into force on November 14, 2012. The objective of the Act is to provide a legal framework to deal with sexual offences against children and to provide for separate courts and procedures for trial of sexual offences against children. Prior to the enactment of POCSO, all sexual offences against children were dealt with within the framework of the Indian Penal Code 1860, that is the IPC. In this module, we will deal with the following. First, the history of laws relating to child sexual offences in India. Second, the framework of the POCSO Act and the offences under the Act. Third, special procedures under the Act for investigation and trial of offences. And fourth, presumptions under the Act. So let's begin by looking at the history of child sexual abuse in India. As discussed earlier, prior to the enactment of POCSO, cases relating to child sexual abuse were dealt with within the framework of the IPC. Section 354, that is outraging the modesty of a woman, covered cases involving non-penetrative acts against female children. Section 377 applied to penetrative offences against children of both genders. Section 375, that is rape, was applied in cases of penile vaginal penetration involving female children. One of the cases that exemplified the need for a separate legal framework to deal with child sexual offences was State of Punjab versus Major Singh, reported in AR 1967, Supreme Court, page number 63. In this case, the accused had inserted his finger into the vagina of a baby girl who was 7.5 months old. He was charged under section 354 of the IPC for outraging the modesty of a woman, since section 375 covered only cases involving penile vaginal penetration. The trial court acquitted the man of the charge, holding that a female infant of that age would not have developed modesty. On appeal, 2 of the 3 High Court judges agreed with the trial court. The Supreme Court was also split on the issue. Chief Justice Sarkar, in his dissenting opinion, agreed with the trial court and the majority opinion in the High Court and opined that the offence would only amount to causing simple hurt. However, the other 2 judges ruled that the focus of section 354 was the intention of the accused. Since he had the intention to outrage the modesty of the baby girl, he was held guilty under section 354 and sentenced to imprisonment for 2 years. The fact that an egregious violation of the body of a female infant could amount to simple hurt and not to a sexual offence, and that judges from the trial court to the Supreme Court were divided on whether section 354 applies or not, indicated that section 354 was not ideal to deal with cases of child sexual abuse. Further, section 354 is not gender neutral qua both the offender and the victim, and hence cannot be used in cases involving boys. The next case which highlighted the need for a separate legal framework for child sexual abuse was Sudesh Jaku versus KCJ, reported in 1998 Criminal Law Journal, page number 2428 of the Delhi High Court. In this case, the victim was a 6-year-old girl. She was sexually abused by the accused, her father, over a period of time. The penetrative acts involved were finger anal, finger vaginal, and penile oral penetration. The father was charged under section 354 and 377 of the Indian Penal Code and not for rape under section 376. The victim's mother challenged the order of charge. She argued in the High Court that since the acts are of non-consensual penetration, the accused should be charged of rape. However, the court did not agree and upheld the order of charge. It laid down guidelines for the manner in which the statement of the victim should be recorded. The case was appealed to the Supreme Court. In its judgment, Sakshi vs. Union of India, reported in 2000 volume 5 Supreme Court cases, page number 518, the Supreme Court upheld the decision of the High Court and ruled that Parliament should consider making changes to the law. The Protection of Children from Sexual Offences Act was finally enacted in 2012. So let us first look at offences under the POCSO Act. The POXO Act punishes a range of sexual offences against children. Penetrative acts, non-penetrative acts involving physical contact, sexual harassment, and using children for pornography. Section 2D of the Act defines child as a person under the age of 18 years. In this section, I discuss each of these offences in detail, beginning with penetrative sexual assault. Section 3 of the POXO Act defines and punishes penetrative sexual assault. The section is gender neutral, both with respect to the offender and the victim. It covers penile penetration of the vagina, mouth, urethra and anus of the child, insertion of any object or body part other than the penis into the vagina, urethra or anus of a child, the manipulation of any part of the body of the child so as to penetrate the vagina, anus, urethra or any other part of the child's body, and application of the mouth to the penis, vagina, anus or urethra of a child. It further covers situations where the offender makes the child engage in the penetrative act either with him or her or with a third person. The section does not require the prosecution to prove mens rea on the part of the offender. The offence is constituted as soon as the penetrative act takes place. The punishment for committing penetrative sexual assault is provided in section 4. The minimum punishment is imprisonment for a period of 7 years and the maximum is imprisonment for life. The judge does not have the discretion to sentence the offender to punishment for less than 7 years. Now let's look at the offence of aggravated penetrative sexual assault. Section 5 of the POXO Act provides 21 circumstances where penetrative sexual assault amounts to an aggravated act. The first circumstance, defined in Section 5A, is where penetrative sexual assault is committed by a police officer. It lists 4 circumstances where such assault is considered aggravated. These are: first, if the act is committed within the limits of the police station where the person is appointed or the premises of such police station. Second, if the act is committed within the limits of a police station irrespective of whether the police station is within the limits of the jurisdiction where he is posted. Third, in the course of his duties or otherwise. Fourth, in a place where he is known or identified as a police officer. This provision recognizes that police officers are in a position of authority due to their position and that there is a power differential between them and common citizens, especially children. The third and fourth circumstance indicate this thought of the legislature since it focuses on the status of the person as a police officer. This is in contrast to the Indian Penal Code, where rape by a police officer is considered aggravated only if the rape is committed within the limits of the police station where the accused is posted, or in the premises of a station house, or if the woman is in the police officer's custody or in the custody of a person subordinate to him. A similar approach is taken by the POXO Act in relation to rape by members of armed forces or security forces, and that is defined in Section 5B of the Act. It covers situations where such member of the armed or security forces commits penetrative sexual assault on a child in 4 situations. First, within the limits of the area where he or she is deployed. Second, in any areas under the command of the forces or armed forces. Third, in their duty or otherwise. And fourthly, where the person is identified as a member of the security or armed forces. Here again, as in the case of police officers, the status as a member of the armed or security forces is considered sufficient to make the penetrative act an aggravated one. Other circumstances considered aggravating are: first, where a public servant commits penetrative sexual assault on a child. Second, where penetrative sexual assault is committed by a person who is on the management or on the staff of a jail, remand home, protection home, observation home, or any other place of custody or care on a child who is the inmate of that institution. Another related circumstance is where a person in the ownership, management, staff of any institution providing services to a child commits penetrative sexual assault on the child. Third, where a person on the management or staff of a hospital commits penetrative sexual assault on a child in that hospital, private or government. Fourth, when a person on the staff of an educational institution or a religious institution commits penetrative sexual assault on a child in that institution. Fifth, when a person commits penetrative sexual assault using deadly weapons, fire, a heated or a corrosive substance. Sixth, when a person commits penetrative sexual assault and causes grievous hurt or bodily harm and injury or injury to the sexual organs of the child. The seventh circumstance covers situations where the penetrative sexual assault physically incapacitates the child or causes a mental illness or causes an injury to the child that temporarily or permanently renders the child incapable of performing regular tasks. If a female child becomes pregnant as a result of penetrative sexual assault, the assault is considered aggravated. The ninth circumstance is where the offender transmits HIV to the child or transmit any other life-threatening disease or infection. And the set of circumstances which makes penetrative sexual assault aggravating are: first, where the offender takes advantage of the mental or physical disability of the child, and second, where the child is less than 12 years of age. These two circumstances recognize the vulnerability of the child both in terms of young age and cognition. Committing penetrative sexual assault on a child repeatedly is also considered aggravated. An allied aggravated act is where the offender has already been convicted for an offence under the POCSO Act or any other sexual offence under any other law. Penetrative sexual assault committed by people in positions of trust vis-a-vis the child are also considered aggravated. These include penetrative sexual assault by a person who is a relative of the child, maybe through blood, adoption, marriage, guardianship, foster care, or by a person in a domestic relationship with a parent of the child or who lives in the same household or shared household with the child. The definitions of domestic relationship and shared household are the same as in the Protection of Women from Domestic Violence Act of 2005. If the offender commits penetrative sexual assault on a child knowing her to be pregnant, or where the person commits penetrative sexual assault on the child and attempts to murder the child, or when the penetrative sexual assault is committed in the course of communal or sectarial violence, these circumstances are also considered aggravated. Commission of penetrative sexual assault by a group of persons in furtherance of their common intention is termed gang penetrative sexual assault and is also considered aggravated. The final circumstance which makes penetrative sexual assault aggravated is where the offender commits penetrative sexual assault on the child and makes the child strip or parade naked. The punishment for committing aggravated penetrative sexual assault is provided in Section 6 of the POCSO Act. It provides for a minimum sentence of 10 years and a maximum sentence of imprisonment for life. The one thing to be noted in this circumstance is that some of the punishments for some of the acts noted in aggravated penetrative sexual assault are higher under Section 376 subsection 2 of the Indian Penal Code as compared to the POCSO Act. Hence, in 2013, when the Criminal Law Amendment Act was enacted, an amendment was made to POCSO as well, which says that a charge should be framed both under the Indian Penal Code and under POCSO, and the punishment, whichever is higher, is to be given. So, for instance, in the case of, say, custodial rape, if a charge is filed both for custodial rape under Section 376(2) of the Indian Penal Code and under aggravated penetrative sexual assault under POCSO, since the punishment under 376(2) is higher, that will be taken in contrast to the charge under POCSO. Now, let's move to the offence of sexual assault. Section 7 of the POCSO Act defines the offence of sexual assault. If a person touches the penis, vagina, breast or anus of a child with sexual intent or does a non-penetrative act which involves physical contact, albeit with sexual intent, these acts amount to sexual assault. Note that the distinction between penetrative sexual assault defined in Section 5 and sexual assault defined in Section 7 is that the latter does not require the element of penetration. So, for instance, if a person touches the waist of a child and it is proved that the touching was with sexual intent, then the act amounts to sexual assault. The term sexual intent is, however, not defined in the act. Hence, it's a question of interpretation by the court whether the acts of the person were done with sexual intent. In contrast to POCSO, the UK Sexual Offences Act of 2003, which has a similar intent requirement, defines the term sexual intent. Section 78 of that Act says penetration, touching, or any other activity is considered sexual if a reasonable person would consider the act to be sexual by its very nature or by the virtue of the nature and circumstances of the act, it is sexual. With such an explanation missing in POCSO, the intent requirement remains vague, which may lead to both under-inclusion and over-inclusion. Section 7 also envisages situations where the offender makes the victim engage in non-penetrative acts with him or her. Hence, if the offender makes the child touch her vagina, breast or anus, or his penis or anus, the act amounts to sexual assault. The punishment for the offence of sexual assault is provided in Section 8. The minimum punishment is imprisonment for 3 years and the maximum is imprisonment for 5 years. Aggravated forms of sexual assault are listed in Section 9 of the POCSO Act. The same 24 circumstances considered aggravated in the case of penetrative sexual assault defined in Section 5 are considered aggravated in the case of sexual assault as well. The only circumstance that is dropped in Section 9 is making a female child pregnant through penetrative sexual assault, which by its very nature is not possible in the case of sexual assault. The punishment for aggravated sexual assault is provided in Section 10 of the Act. The minimum punishment is imprisonment for 5 years and the maximum punishment is imprisonment for a period of 7 years. Now let's look at the offence of sexual harassment under POCSO. The POCSO Act provides the definition of sexual harassment in Section 11. If a person commits any of the following acts with a sexual intent, they will amount to sexual harassment. First, utters any word, makes any gesture, or exhibits any object or body part with the intention that such word, gesture, object or body part is seen or heard, as the case may be, by the child. Second, makes the child exhibit his or her body or a body part so that it may be seen by the offender. Third, shows any object to a child for pornographic purposes. Fourth, repeatedly or constantly follows, watches or contacts the child directly or through digital, electronic or other means. Fifthly, threatens to use in any form or media a real or fabricated depiction through electronic, film or digital or other mode or any part of the body of the child or involvement of the child in a sexual act. Sixthly, entices a child for pornographic purposes or gives gratification therefore. As is evident from the section, the definition of sexual harassment includes the definition of other offences as defined in the Indian Penal Code. For instance, the offence of stalking is covered in the 4 circumstances listed in Section 7. The definition of sexual harassment in Section 11 is also different from the definition of sexual harassment in Section 354A of the IPC, which defines the same offence. In contrast to Section 7 of POCSO, where reference is made to sexual intent without providing further guidance as to what it means, the explanation to Section 11 takes an additional step. It states that the question of whether the act concerned has been done with a sexual intent shall be a question of fact. The punishment for sexual harassment is provided in Section 12. The maximum punishment is imprisonment for 3 years. Unlike penetrative sexual assault and sexual assault, a minimum sentence is not provided in case of sexual harassment. Another difference is that specific aggravating circumstances are also not mentioned in the case of sexual harassment. Now to look at other offences under the POCSO Act, in addition to penetrative sexual assault and sexual harassment, POCSO also criminalizes certain other acts. Section 13 of the POCSO Act punishes the use of a child for pornographic purposes. So if a child is used in any form of media for the purpose of sexual gratification, that act comes within the purview of Section 13. Representation of sexual organs of a child or usage of a child engaged in real or simulated sexual acts, both with or without penetration, or the indecent or obscene representation of a child are covered within the ambit of the section. The offence extends not only to print media but also to electronic media, computers, or using any other technology for the preparation, production, offering, transmitting, publishing, facilitation and distribution of pornographic material. The punishment for using a child for pornographic purposes is provided in Section 14. A range of punishments proportionate to the acts committed have been prescribed. A maximum punishment of 5 years is prescribed for using a child for pornographic purposes. If the person commits penetrative sexual assault by directly participating in the pornographic acts, a minimum punishment of 10 years imprisonment has been prescribed, with the maximum punishment being imprisonment for life. If the pornographic act involves an act of sexual assault, the maximum punishment is imprisonment for life. A minimum punishment has not been prescribed in such a case. On the other hand, if the pornographic act involves an act that amounts to sexual harassment, a minimum sentence of 6 years and a maximum sentence of 8 years has been prescribed. Storage of pornographic materials that involve children for commercial purposes is also an offence under the POCSO Act. The Act in Section 23 also places certain restrictions on media reporting relating to children. Recognizing the impact of media reporting on the child's well-being, including its privacy, the Act bars the media from disclosing the identity of a child. Non-disclosure of identity extends to not reporting the name, address, photograph, family details, school, neighborhood, or any other details which may lead to the child being identified. Contravening Section 23 leads to a minimum punishment of imprisonment for 6 months and a maximum punishment of imprisonment of 1 year. In terms of reporting of offences under POCSO, the POCSO Act, as we know, is a special statute which specifically deals with sexual offences against children. Consequently, it also provides for differential procedures relating to reporting, investigation, and trial of sexual offences committed against children. The aim of the reporting procedure is to make it simple if the reporting is being done by the child himself or herself. Hence, the Act attempts to provide age-appropriate and child-friendly procedures in accessing the criminal justice system. Unlike the CRPC, which under Section 39 mandates that the public report certain set of offences punishable under the Indian Penal Code, the POCSO Act requires anyone who knows that an offence under the Act has taken place or has the apprehension that an offence is likely to be committed to mandatorily report the offence. The Act in Section 19 states that such complaint may be made to the local police or to the Special Juvenile Police Unit. A report filed by the child is required to be recorded in simple language. This is stated in Section 19, subsection 4 of the Act, and an interpreter is to be provided to the child if required. This is stated in Section 19, subsection 5 of the Act. On the offence being reported, if the police or the Special Juvenile Police Unit are satisfied that the child against whom an offence has been committed under the POCSO Act is in need of care and protection, they are required to make arrangements for such protection within 24 hours of the report being filed. This is mandated in Section 19, subsection 5 of the Act. The SJPU is also required within 24 hours to inform the special court set up under the Act and the Child Welfare Committee set up under the Juvenile Justice Act of the commission of the offence against the child. This is mentioned in Section 19, subsection 6 of the Act. As noted earlier, the POCSO Act provides for mandatory reporting of offences committed under the Act. It places a special obligation on media outlets, hospitals, hotels, clubs, studios, and photographic facilities to immediately report the commission of an offence under the Act if it comes to their knowledge. Section 20 of the Act, in placing this obligation on specific entities, takes note that these entities are likely to become aware of commission of sexual offences against children. In order to ensure that there is no impunity with relation to child sexual offences, mandatory reporting provisions of this nature have been introduced, which also criminalize failure to report. Similarly, if a person other than those mentioned in Section 19 comes to know that an offence under the POCSO Act has been committed or has apprehension that an offence is likely to be committed and does not report it to the police, such person is also liable to be punished under the Act. A maximum sentence of imprisonment for 6 months is provided for non-reporting of offences under the Act. However, this mandatory reporting requirement is not applicable to a child. Further, if a person in good faith reports his or her apprehension that an offence under the POCSO Act has been committed, he or she is provided immunity against any civil or criminal liability as mentioned in Section 19, subsection 7. In terms of recording the child's statement, as a corollary to Section 19, which deals with reporting offences under POCSO Act, Sections 24 and 25 of the POCSO Act deal with the manner in which the child's statement is to be recorded, first by the police and then by a magistrate. Section 24 mandates that the statement of the child shall be recorded at a place of the child's choice, or at the child's residence, or at a place where the child usually resides. The statement is to be recorded by a woman police officer, not below the rank of sub-inspector of police. The child should not be detained in the police station at night, nor should its identity be disclosed to the media. The Act mandates that the police officer shall ensure that the child does not come into contact with the offender during the investigative process. Further, the identity of the child is not to be disclosed to the media. The POCSO Act also provides for procedures in relation to recording the statement of the child under Section 164 of the CRPC. It requires the magistrate to record the statement as spoken by the child. This ensures that the magistrate does not provide his or her understanding of what the child may be saying, but records the statement in the exact words of the child. Section 25, which provides the procedure, also states that the advocate for the accused need not be present while the statement of the child is being recorded. It ensures that the least number of people required are present in the room when the child's statement is being recorded by the magistrate. This ensures that the child is comfortable while recording his or her statement and is not re-victimized or subject to additional trauma during the process. Section 26 of the POCSO Act provides guidelines for recording of statements of the child. These guidelines apply both to magistrates and police officers when they record a child's statement. It states that the statement should be recorded in the presence of the parents or a person who the child has trust and confidence in. Where necessary, a translator or an interpreter should be used. In case the child is physically or mentally challenged, the Act states that a special educator may also be used who can assist in the recording the statement of the child. Wherever possible, the statement of the child should be audio or video recorded. The Act also provides the procedure for medical examination of the child. Section 27 of the POCSO Act lays down the procedure for such medical examination. It states that medical examination of a child who has been subjected to an offence under the Act shall be conducted in accordance with Section 164 A of the CRPC. It also states that such medical examination shall be conducted even if a formal complaint or FIR has not yet been lodged. It mandates that a girl child shall only be examined by a female doctor. The medical examination is required to be conducted in the presence of a parent or any other person who the child has confidence in. Where such person cannot be present, the medical examination is to be conducted in the presence of a woman nominated by the head of the medical institution. In the context of medical examination, the Act also provides an exception from sections 3 to 13. Section 41 of the Act states that if medical examination of a child is conducted by a doctor, or if medical treatment is given to a child which involves acts of the nature prescribed by sections 3 to 13, and the parents have consented to such medical examination or treatment, the offence shall not be constituted. Now, dealing with special courts and prosecutors, the POCSO Act provides for the establishment of special courts to try offences under the Act. Section 28 of the Act mandates the designation of a court of session as a special court. It is ideal that a special court exclusively try offences under the POCSO Act, since the Act provides for various measures to ensure child-friendly atmosphere during the trial. However, the practice in most states in India has been that a sessions court where trials of other serious offences under the IPC and other special legislations take place are generally designated as special courts under the POCSO Act. This may in fact lead to the purpose of the statute being defeated. Hence, it is ideal that exclusive special courts be set up under the Act. This has recently been done in fact in Delhi, where exclusive special courts have been set up. In order to ensure that trained and specialized prosecutors conduct prosecution of cases under the POCSO Act, Section 32 of the Act requires state governments to appoint special prosecutors. The Act also provides for procedure to be followed while conducting trials under it. These procedures are laid down in Sections 33 to 38 of the Act. Trials are required to be in camera. They are to be conducted in the presence of the parents of the child or any other person in whom the child has trust and confidence. Section 37 mandates this. All questions to the child have to be routed through the judge. The court may also provide regular breaks during the recording of the testimony of the child. The court is mandated to create a child-friendly atmosphere. The court should avoid calling the child repeatedly to testify before it. A time limit of 30 days from taking of cognizance is mandated for recording of evidence of the child. A time limit of a year from the date of cognizance is suggested for completion of the trial. Courts are also mandated to ensure that the dignity of the child is maintained throughout the trial. Courts are also required to ensure that the identity of the child is not disclosed at any time during the investigation or trial. Innovative steps may be taken by courts in this regard, including using curtains, almirahs, one-way mirrors, etc. This is provided in section 36. In Delhi, vulnerable witness courtrooms have been set up wherein children testify from a different room in the court complex which is connected to the courtroom through a video link. The child only interacts with the judge through this video link and is kept away from the accused, lawyers and other people who may be in the courtroom. The court may also in appropriate circumstances appoint commissions to examine the child in a place other than the court. Proviso to section 37 provides for this. Assistance of translators, special educators or interpreters may be taken by the court in appropriate cases as and when required. The POCSO Act also requires state governments to prepare guidelines for using NGOs and experts to assist the child during the legal process. Section 39 provides for this. The child is also entitled to assistance of his or her own counsel. The Legal Services Authority is to provide a counsel if one is sought by the child, and section 40 mandates this. Thus, a series of steps and conditions are mandated by the Act to ensure that child-friendly procedures are followed in the legal process. Coming to presumptions under the Act, one of the major differences between POCSO and most other criminal legislations is presumptions that the Act creates. Section 29 creates a presumption relating to certain offences. It states that where a person is prosecuted for committing, abetting, or attempting to commit an offence under sections 3, 5, 7 or 9 of the Act, the special court shall presume that the offender committed the offence unless the contrary is proved. Hence, a presumption of guilt is created under the Act. Further, section 30 raises presumptions relating to culpable mental states. Where POCSO requires that culpable mental state be proved, such as in the offences of sexual assault and sexual harassment as discussed earlier, the Act states that the existence of such a culpable mental state may be presumed. However, the presumption is rebuttable by the defence. Unlike other offences where the principle of evidence law is that general exceptions are proved on preponderance of possibilities and not beyond reasonable doubt, POCSO requires that the lack of culpable mental state should be proved beyond reasonable doubt by the defence. Proving the existence of a culpable mental state is indeed a difficult task. However, in attempting to safeguard the sexual autonomy, bodily integrity and interests of the child, the rights of the accused should not become a casualty. In conclusion, the Protection of Children from Sexual Offences Act is indeed a progressive and much needed legislation to effectively deal with the ever increasing sexual offences against children. In addition to defining various offences, the Act also attempts to provide better and effective access to the legal system to the child. It aims to create a child-friendly and sensitive criminal justice system where children are victims of sexual crimes. Thank you.